Okay, everybody, since we're recording this, I think we should get started because there's a lot to cover tonight. We have a lot to say. And we want to give you the opportunity also to respond to some of this and give us your comments and questions in the chat. So thank you for joining us tonight and for this discussion on this landmark decision by the Constitutional Court of Ecuador, utilizing rights of nature to protect the Los Cedros cloud forest. And I'm looking down the list and I see a lot of folks, not just here from the US, but folks from around the globe. And we want to say welcome from Turtle Island, which is where we're all at here at CELDF. We also want to thank and acknowledge the indigenous people of Ecuador and around the world for their stewardship of the natural world and for setting the necessary example for the rest of us. We also want to acknowledge that indigenous people have recognized nature and Mother Earth as a living being and deserving of respect, that humans have obligations to protect her from the very beginning of time. It's the foundation of what we're now calling in Western law, rights of nature. And hopefully through the work so many of us are doing on rights of nature around the world, we're helping more people realize that no matter what nation, bioregion, or watershed we reside in currently, that harms done to another nation, bioregion, or watershed can and do affect us all, whether we realize it or not in the moment. And the successes also affect us all. And that's why we at CELDF are a bit excited about this court decision in Ecuador and wanted to share some of our thoughts about it with all of you tonight. And just to add, this is a very complicated decision and we won't be able to cover it all tonight, but we want to focus on some of the highlights, and then we plan to follow up with more discussions, and we will invite you and others to share your perspective once you've had the opportunity to read the decisions, because we will be posting it, the English translation, on the website and sending it to you. As many of you know, CELDF has been working on rights of nature for a little while now. And we feel a connection to this case through the efforts that we did starting in Tamaqua back in 2006, as the first time rights of nature was included in Western law. And I know Kathy Miarelli had signed up for the webinar. I don't know if she's on or not, I haven't seen that, but she had something to do with that. And so thank you, Kathy. Well, that then led to being part of a larger effort 2 years later in the work we did with many other people to include rights of nature in the Ecuadorian constitutional rewrite. And we want to acknowledge the folks at the Global Alliance for the Rights of Nature who have continued to be active in Ecuador and around the world on pushing rights of nature forward. And we especially want to thank Natalia Green, who I see is on the webinar this evening. And she was very instrumental in working with us to get this decision translated into English. And she's also going to be our expert if any questions come up about the Ecuadorian judicial system. And we were hoping to share with you this evening exciting new artwork that we've commissioned to represent visually what we believe the rights of nature movement represents. But it's not quite complete, and so we will unveil that to you shortly. You'll receive an email with the finished, gorgeous artwork done by two amazing artists, Blake Lavia and Sinsun Aguilar Itzo, also known as Talking Wings. We'll be putting their website in the chat so that you can see how amazing they are for yourself. And they're also working in their local community of the North Country to put forth a rights of nature law for the St. Lawrence River watershed. I do have in my background, you'll see it's a little sampling, a little preview of what the artwork is going to look like. So with that, let's get started with the content for this evening. And I quickly want to let you know that this evening we have joining us from CELDF organizers Ben Price in Pennsylvania, Chad Nicholson, who is also located in Pennsylvania, and attorney Terry Lodge in Toledo, Ohio. I'm Tish Odell, and I'm an organizer with CELDF as well, and I'm located in Cleveland, Ohio, and only a few miles from the shores of Lake Erie. I'll be attempting to keep this conversation on track tonight, but we all get pretty passionate when we talk about nature, so we'll see what happens. We want to cover, like I said, some of the key points we took from the decision, but we also want to encourage all of you to type questions or comments into the chat, and we'll try to incorporate these in. And just so you know, this is an introduction, and your questions are going to help us shape future webinars that we're planning this fall on the rights of nature movement. For those of you who have not read the case, I want to give you just a brief background so you know who some of the characters are. The parties or the players in the case are Anami EP, which is a national-owned mining company. They work with a large Chilean corporation also called Codelco. And then the other party, which is the local municipality that brought the lawsuit, you'll see referred to as GAD, which stands for the Autonomous Decentralized Municipal Government of Cotacachi. So it was the local municipality who sued to stop the mining of the Los Cedros cloud forest. And this case was brought as an appeal from a lower court to this Constitutional Court, which is the highest court in Ecuador. The lower court decided more along the lines of traditional law. And I want you to think about the fact that even though the forest is labeled as protected, a permit was still issued to mine there. So think about that labeling. Does that really protect it? This decision, however, reversed the lower court and revoked the permit. And the makeup of the court, so you know, in Ecuador is 9 judges, and 7 judges ruled in favor of the forest and 2 gave dissenting opinions. So with that little bit of background, let's get started here with the discussion. And I'm going to start off with Ben, and then of course, the rest of you join in with your comments after Ben starts it off. So the first question to throw out there is, what would you say is the significance of the Los Cedros decision for the future development of rights of nature, not only in Ecuador, but globally? Unmute, Ben.
Thanks. Thanks, Tish, and welcome everybody. And I think that it is really a significant outcome from the Los Cedros decision from the Constitutional Court. Clearly, there is constitutional language adopted in 2008 recognizing the rights of Mother Earth, of Pachamama. And this is something unique. It was the very first nation on Earth to do so, and it still remains in some ways unique in that it is simply a recognition of the vesting and the existence of these fundamental rights in ecosystems, in nature itself. The fact that it's part of the Constitution means that it gives the courts an opportunity to look at that language. And for lack of very deep precedent, there have been a couple of prior cases and some precedent set. But really, what I find significant is that the court begins to expand and deepen the meaning of the constitutional language in its decision. It begins to flesh it out and define terms. It begins to be very clear about what those rights of Pachamama are and who has standing before the court, who has legal authority to come to court to present and defend those rights, and on what grounds and using what standards. And we'll be talking about that a bit more, the standards that are used and so forth. But, you know, here I'm in the United States and I work, and so do my colleagues here, work with communities across the United States on rights of nature measures. And we don't have the benefit of a constitution that is so heavily influenced by a strong indigenous cultural tradition as it is in Ecuador. What we have is a constitution that is rooted in the protection of property interests and rights associated with property and the accumulation of wealth, and finding means an entree into this structure of law in the United States and in other nations with similar basis for legal judgments, there's a real challenge compared to what Ecuador has before it. The courts do there with the Constitution. So one of the things that that we do aim for is to associate the people in a given community with their local ecosystem, and to declare that those communities of people have legal standing before courts to speak on behalf of the ecosystem of which they are an integral part. Now, we understand that that's at odds with traditional Western legal thought, but it is the direction that we are trying to move things in redefining the status of nature under existing law. And frankly, that means changing the status of ecosystems, of nature as a whole, out of the realm of property, so that that's not the only legal status that it has in the eyes of the law, into the realm of actually being a rights bearing entity. And I'm going to let others speak here just a second. I just wanted to say that there's a couple of really, I think, fundamental, important elements to this decision. One of them is the role that the local community plays in determining the outcome of the controversy between the mining company and the community and the forest. Who gets to say, who gets to decide? That's really at the root of it. One other point I wanted to bring up is that nowhere in the decision and nowhere in the Ecuadorian Constitution do we see the term personhood or juristic or legal personhood associated with Pachamama, with Mother Nature. That's not the framing of the rights of nature in Ecuador, although we know that it is the language and the framing elsewhere. And I think that that's something, maybe it's too broad of an issue to talk about tonight, but I think that it's something that we'll need to dive into in future conversations. So let me pause there and see if there's any other thoughts.
Yeah, thanks, Ben. I'll open it up to the other two.
Well, I think that it is an enormously significant decision because of the fact that it's extremely well written. It's very clear that the Ecuadorian court understood that it was writing for a much larger audience than simply a national one-over-one project. It's extremely well conceived, and also it's consistent with what I think has been emerging for some time, which is the fact that the change in the evolution in the direction of rights of nature is largely going to happen outside of the United States and perhaps other Western countries. Just today in the United States, there was an enormous setback, retrenchment forced by a very conservative National Supreme Court, which has effectively severely clipped the reach of the so-called regulatory state, where regulatory agencies have, to some extent, the power to decide what and how to regulate. Perhaps that will give a boost to alternative approaches like rights of nature. But for the time being, I think things are going to be extremely crippled from the standpoint of major environmental progress in at least this Western North American industrialized country.
Chad, did you have anything to add, or?
Not in this question, thank you.
Mm-hmm. I just am going to add, I'm going to say, you know, I think, you know, we've all witnessed firsthand in this country, you know, the laws being words on paper, you know, and we can see, especially what's happened in the last week or so, that they can change at the whim of whoever, you know, has the power to do that. And so you know, I'm just inspired because being involved with the Lake Erie Bill of Rights and saw what the judge did with that this to me is really inspiring, because I was starting to give up completely that any judges would ever recognize rights of nature. So yeah, I'm very grateful to read this. And I think the rest of you, when you read it, it'll be pretty inspiring to you as well, but also recognizing that it can change. So, you know, we have to be vigilant in, I think, keeping up the idea that the laws have to represent the values of the people, and that we have to not just go, oh, well, this is a great decision that we got in my community, and so we don't have to pay attention anymore. And so I think that's important. We have to see if we can use this to move it forward, the movement for rights of nature in other places.
If I could, I just adding on, I think what Terry is referring to is actually a Supreme Court, United States Supreme Court decision, really gutting regulatory agencies and law and their authority to enforce any kind of regulations on corporations, on extractive industries and so forth. It's distressing, and yet the rights of nature, as we often talk about, is not about regulating environmental protections. It's not about regulating the rate at which the natural environment is allowed to legally be destroyed, but instead of finding legal rights vested within the natural systems. And that's significant. And what's really very significant to me as a community organizer, working with community members and explaining what it is we mean by rights of nature. And then afterwards, finding ourselves in litigation, being challenged for daring to express rights of nature in laws that thwart extractive industries often. What we hear from the courts is, well, your laws are too vague. They're so vague, we don't even know how to enforce them. And what I find significant about the Constitutional's Los Cedros decision is that a lot of the ill-defined terms, perhaps, that we have advanced and tried to suggest in some of our laws have been fleshed out by the court's decision, have been stated in language that can be borrowed, that can be referred to elsewhere. I frankly assume that I'm going to be borrowing shamelessly in the future from this decision, and I'm happy for it.
Yeah, thanks, Ben. That's what I'm hoping too, that this at least shows people what it can look like, including judges. Judges are people too, right? This is what it looks like to write a decision where rights of nature is recognized, and you know, it sets precedent, and hopefully they'll pull from it, just like not just us, hopefully they will too. So if we're ready, I'm going to move on to our next question, and I'm going to ask Terry for his thoughts on this one first, because of his many years of practicing Western environmental law and trying to make it work to actually protect the environment and people. So the decision talks a lot about the precautionary principle and having enough scientific data to prove that the activity or project won't harm the Los Cedros Forest or the water or the community. And several of the concurring opinions that were written, and I believe one of the dissenting opinions also seems to mention this as a problem. So what are your thoughts on this?
Thank you, Tish, and welcome everybody. I didn't mention that earlier. The precautionary principle is something that has been discussed in the environmental circles in the United States for a long time, and is a very worthy and useful concept, particularly in Ecuador, where it is inscribed along with what's called the restrictive or preventive principle. Both are included in the constitutional changes that were brought about some years ago to the Ecuadorian Constitution. The problem is this, that many high-tech or highly technological methods of extraction, such as strip mining, such as mountaintop removal mining, and with enormous heavy earth-moving equipment, Nuclear power is a high-tech type of means of generating electricity. The increasing deployment in Northwest Ohio, for example, of a proposed genetically modified salmon factory. All of these are major projects with lots of implications and incompletely understood science. Incompletely understood in the case of mountaintop removal mining, the devastation from modern massive mining techniques is so enormous that its effects on ecosystems, perhaps even physically, geographically far from the site, are not well understood. With nuclear power, at least in the early days, the industry made certain, along with the federal government in the United States, that lies were told, and it was very difficult, if not impossible, to ascertain what the public health effects on animals, the environment, and people would be. Again, with the genetically modified mass salmon animal farm, animal factory, it is unknown what the effects, both the health effects from consuming genetically modified animals as food, but also what happens if some of them escape into the ecosystem and reproduce and survive out there, causing all kinds of changes in terms of competition for habitat and other things. So the problem is that a lot of things are undertaken without a complete, or at least a much fuller understanding of science. A lot of that is deliberate political. A lot of it is by design. It has only been quite recently that the federal government has finally commissioned studies of the public health effects of long-time radiation emissions from nuclear power plants. So the precautionary principle and the restrictive preventive principle. First of all, the restrictive preventive is something akin to performance of an environmental impact statement. It identifies areas of science that are relatively well understood or where there is a defined mainstream type of scientific opinion. The precautionary principle, by contrast, is where there is risk, there's foreseeable risk, and it refers to the possibility, but not the known facts about potential serious or irreversible damage. Again, something on the order of not understanding the long-range, long-term effects of massive mining proposals, such as was proposed for the cloud forest in Ecuador, is a big problem. And so you have scientific uncertainty that may be in the form of continuing debate. There's a lack of knowledge, perhaps, or a difficulty in determining what the consequences are. This is what differentiates precaution from prevention. You prevent the things that are pretty well known and accepted and that are easy to identify and mitigate or avoid completely. The precautionary principle is a very conservative one, however, that says because we don't know as much as is necessary to really scope out, suss out the effects of this project, we're denying permission for the project to go forward. It places a very heavy burden, as opposed to the usual regulatory model, puts a heavy burden on the usually private corporation or governmental entity that's pushing the project. It means that they have to come up with significant scientific evidence that can be scrutinized and vetted for its accuracy. The contemporary model, and I think in terms of permitting, for instance, for the hydraulic fracturing, the fracking of oil and gas wells in many of the Eastern American states, that basically you provide engineering drawings, some assessments from time to time of what the risks are and what the potential geological problems are. But overall, in most instances, the permit applications just basically acknowledge that, yeah, there's geology. Yes, there may be some problems there. We're not real clear on what could happen because we only have an incomplete idea of what the Earth's crust really looks like and what water or other features there are within the bedrock and the other layers. So what you have is, yeah, there's some science, but it is incomplete. And typically the regulatory model as implemented in these United States largely denies much opportunity for public questioning or scrutiny. Often the public doesn't have the resources. Often they don't have notice or time or opportunity to really weigh in and take a long look at an application. But the scientific faults are very frequently there, and often they are incredibly obvious. But the agency is still allowed to effectively take note of public opposition or even authoritative and scientific public comments, but steamroller on ahead with the project. So the precautionary principle fits well in the Ecuadorian scheme of things because of the fact that we are talking about a situation where ecosystems, that effectively nature is placed above human activity in the hierarchy of things that must be protected. And in protecting, you have to investigate the best science and try to acquire the best understanding of what the effects could be and determine whether or not, in effect, the permitting entity knows enough about the project that it can make a decision for the ages, because that is, in effect, what an awful lot of these determinations are. They are permanent changes and damage and reduction of the quality of the environment, both for human as well as animals.
Yeah, it's really interesting, Terry. That's what I found interesting in the decision. I mean, the court actually speaks to some of what you talked about with, you know, the information, and it has to be clear. It has to be not the corporation can't, you know, create all this information. It has to be objective. I think that's the word they used in it, that it has to be understandable and formatted in language that's neither technical nor obscure.
Right.
You know, they have all they covered so much of that in the decision itself. So
Indeed they did. And it's worth going through and digesting it kind of slowly and deliberately. This is a really, it's a remarkable decision, but it covers a host of topics in really heavy detail. And I mean, they've really touched upon a lot of the considerations.
yep.
Yeah, and I mean, kind of maybe foreshadowing the next question as well, but like, who gets to make those determinations? Is it the EPA, or, you know, which has just been gutted again? Is it the communities? Is it the ecosystems with humans acting on their behalf? Whatever it may be, but I think that's the thing that sticks out to me in all of this is we're getting new guidelines, and I think that this decision from the Ecuadorian court is really helpful in that sense. But ultimately, like, who are we looking to for authority on these issues? And yeah, I'm not answering that question. I'm just asking it because I don't think it's going to be the people that we're used to looking towards. It's not going to be our state or federal regulatory agencies. It's not going to be necessarily even our local watershed, people that know what the hell's going on where we live. It's going to be us that live there. And so, yeah, where do we look to for the authority? And is it some sort of external source, or is it those of us who live in a place?
I just wanted to point out that kind of the speaking in kind of in the terms that I would approaching folks in a community that are considering enacting a rights of nature measure to protect their local ecosystem. What the court decided in the Los Cedros case, it may only apply in this one case, and it may not be, and it may be just for extractive industries and so forth, but it does create a template, kind of a model for future decisions. And I don't mean just in Ecuador, but elsewhere. And that's, we kind of do tend to try to interpret it and put it in the context of where we are. And that's, in North America. And it's just, but I think it's significant that the precautionary principle is brought in because it switches the burden of proof. It puts the burden of proving that there won't be harm on the proposed industrial activity, as opposed to the burden of proof being on the victims after the fact of being harmed, after the destruction of an ecosystem has occurred, then seeking damages or seeking some kind of compensation for the harm. The proof is still on the victims to actually demonstrate beyond doubt that it was this industrial activity that caused the harm. And I think to your question, Chad, I think that it suggests that it's not going to be the expert opinion. It's not going to be scientific studies that are going to be relied on for the decision. If this decision it stands as the model, that it's going to be the community itself. And I'll put it the way I do speaking with the communities I work with, that the people living within that ecosystem are the experts. They are the experts with the greatest knowledge of that ecosystem. And I don't mean scientific knowledge. I mean practical knowledge of living as part of that ecology. And that to me is a significant paradigm shift, not just in legal terms, but a cultural shift to say that it's the people that we're going to depend on for their wisdom, as opposed to abstract ideas and reductionist theories and so forth.
Yeah, I know one thing that stuck out for me in the decision was, and it was actually a footnote, which I found entertaining because of how we know corporations got their rights and different things like that. And, but where they talked about the states responsible for implementing a process, to what you said, Chad, of participation in community consultation, and that they said this process and community engagement in which the minimum democratic guarantees are fulfilled, such as preparation of the consultation, election day, computation and results of the consultation, challenges to the results, and declaration of the validity. It is not sufficient merely to inform the community of the state decisions regarding acts that could affect people. Rather, it is necessary to secure the right of participation to be consulted. And, I'm reading it and I thought, wow, actually ask the people and hold an election to see what they think of the project. Novel idea in a democracy. But yeah, so that was another part that I thought was really, stuck out to me and I highlighted when I was reading it.
What recognition of the precautionary principle also would do is exert, first of all, it would validate and actually give a lot of support to what happens a lot of times when there is public opposition to serious projects forms. And, people are predicting, or at least anticipating from what little data we have, they're trying to project what deaths would happen and, the parts per million sorts of arguments. But what it would do is it would send a signal that some projects are dead on arrival. I agree with Ben's reference to the fact that that mining would take a perhaps most serious upfront hit because of the fact that it is impossible to envision, for instance, how a lithium mine in northern Nevada that's going to be 400 feet deep and occupy 12,000 acres isn't going to destroy water in the middle of a desert, isn't going to create enormous problems for animal life and plant life that are in endangered desert climates. Asbestos, smoking, things where if the science had been forced out, and I see some comments in chat talking about historically corporations have known, they've known of dangers. The revelations over the last several years about how the oil majors often had done studies commencing as long ago as the 60s or even the late 1950s and predicted climate chaos such as is unfolding now. If you force the science out of them, put the burden on them at the very outset or as close to the beginning as possible, it will snuff things, it will curb things from happening if there is a means of a hard stop. Consultation is not a hard stop. Public comments, let them eat public comments. Those kinds of things are show. They are superficial trappings that are meant to seduce us into believing that we have some sort of say. But you can comment to death, and the agency is free to overrule you or to roll on over with the project.
All right, well, we're already only have about 20 minutes left, so I'm gonna get to Chad because I don't want him to feel forgotten here. And a lot of the decision, and I know questions that people have had and conversations I've had with communities, they want to know about the human right to water, things like that, and how that would, that somehow that will protect nature as well, that if we take and give human rights to a clean environment, things like that, that'll help. Well, in Pennsylvania, you guys have had an environmental amendment in your constitution for several decades. So I thought, you might want to comment on that. We're seeing a lot of communities that have worked with, and we've worked with folks who want to protect that right to clean water for humans. And that somehow that will translate to rights for nature. And what are some of the issues that you think with this way of thinking, and does this decision address some of those?
Yeah, I think, Sish, I was feeling very left out. Yeah, I think it's a really great question, and it's a one I think that gets confused a lot of times when talking about the right of humans to a healthy environment versus the right of the environment to a healthy environment. And I think that's what we're getting at with this decision here. We've had a constitutional amendment that has been in place in Pennsylvania since the early 1970s, which was on the heels of the Clean Water Act, the Clean Air Act, the National Endangered Species Act, there was like a bunch of decisions that happened then around the environmental movement. And so we had Article 1, Section 27, which starts with the people have a right to clean air, pure water. And then it continues on that Pennsylvania's public natural resources are the common property of all the people. So it first identifies any environmental protection as being in favor of humans, but then it also identifies any natural resources, which is another, problematic term, as being something that is the property of the people that live here. So this has been going on for a long time, and we work with communities, and we definitely use Article 1, Section 27, what I just referenced, in some of our litigation. But I think it really is it's a difficult thing to discuss when you're talking about, does the environment exist there for us as humans, or do we see ourselves as a part of it? And that's what I've always seen the rights of nature work is trying to bridge, which is if we're truly honest about being in favor of rights of nature, we have to see ourselves as humans, as a part of the ecosystem, as a part of the place where we live, not separate from it, and not only intending to benefit from it, or not only intending to see it as something that's property. I think in the court, in the Ecuador case, went beyond that, and it looked at it. There was a section 242 where they said, the right to a healthy environment is not only a function of human beings, but also includes the elements of nature as such. So they got there, they went there, they recognized that these types of things are not just about human benefit from the natural environment, but are something different, and that we need to see ourselves as a part of it. And I think that's what a lot of the work that's been done with rights of nature stuff, not just in Ecuador, but in the United States and many other places around the world, whether it was Tamaqua or Grant Township in Pennsylvania, the Lake Erie Bill of Rights in Ohio, is that this isn't just about a shift in the legal framework. And I think this is, a really important part of this discussion. We can't just look to the courts to interpret these things for us. It's not just about changing the law, it's also about seeing ourselves differently within the places that we live. And a lot of the work that happened in Toledo, for example, or Tamaqua, or Grant Township, or dozens of other places that we work, is about humans seeing themselves in a different way within the context that they live. And it's saying, like, we're not just here to exploit or to secure our own healthy environment. We're here because we understand that we're a part of the place that we live. And I think that's one of the biggest things of the Los Cedros decision that stood out to me, was recognizing this isn't just about humans. This is about how humans see themselves within other environments and communities. So. And recognizing that a lot of the legal framework that has come before us, including a lot of the stuff from the 1970s, is inadequate because it does place humans at the center. And the Los Cedros decision, in conjunction with the language in the Ecuadorian Constitution, sees it differently, and that humans are not the center. We're a part of it.
Ben, Terry, you have anything to add? Thank you.
Yeah, in many ways, we talk about it in our work, in educating people about kind of the origins of colonial systems and their impact on not just the natural world, but humans as well. That it's going to take that shift in perspective and seeing how we fit into the world, and that is a real challenge. It requires a paradigm shift. And we're certainly going to meet a lot of opposition along the way, and we are pretty experienced with that. And Terry, on the legal front of things, you've got a lot of experience with the kind of intransigence of the system, because it is so deep rooted, and although it's deep rooted, it's nowhere near as deep rooted as indigenous respect for the natural world, and it goes back much further than even half a millennium or more of colonial settler imposition of transforming the natural world into enclosed and privatized property. But changing that, there's an awful lot to overcome. And there's a lot of villainization of people who attempt to do it as being in some way enemies of the existing order, enemies of decent society, even the way that it's framed. And that's a real challenge for us. But in many ways, I see this as, and this decision as part of a historic movement for emancipating the planet, emancipating nature from the status of human property, just as Africans had to be emancipated from constitutionally approved slavery in the United States. I mean, the fact that things are legal doesn't mean that they're right. We all, that's a kind of a truism, but in our own countries, we have to remind ourselves of that sometimes because we're so indoctrinated into believing the opposite. So at any rate, I think that this is a historical moment, and they think that it's may not be the largest and only, but for the present moment, it's significant and worth pausing to see that.
Yeah, I just want to say in terms of, I'm not a lawyer, but when we think about these decisions, whether it's Los Cedros or other, things that we see around the world these days with rights of nature taking off, the laws and the words are only as good as the people and the values that animate them, that are actually behind them. And, I think it's a question that we're going to be putting out to folks who attended tonight. What do we see the role of courts being in these types of things? And we can write the best laws possible, but if the people aren't there to back them up and to make them real and to animate the values that are inherent in the words that we're putting down on paper, what does it mean? And so, yeah, I think this Los Cedros decision is really a solid framework for moving ahead with some of these discussions. But what do we do in our communities if the courts don't back us up?
Yeah, that's really good. And I'm trying to read in the chat, but now there's a lot more conversation going on in there and it's harder to keep up. But yeah, there's some people who are getting really negative, like, well, in my community, this happened and we lost to the, corporation and they've locked people up in prison. And yeah, I mean, yeah, that's going to happen. You're challenging the powers that be. And so we've had a lot of this. And last weekend, I know in Ohio, the Ohio Community Rights Network showed a film, Patrimonio, that took place in Mexico, and the community tried to protect itself from a big corporation coming in and ruining their community. And the attorney went to jail. He was locked up. The people there were threatened with their lives. Their children were threatened. So yeah, I mean, we saw what happened here in the States at Standing Rock. They're not going to just hand and go, oh my gosh, we see the light now, but what this decision does is it actually gives us something, I think, to point to, because for people who couldn't visualize how would rights of nature, how would this work? How would that be upheld by a court of law? How would it look? So that's at least gives us something to point to now. It's just like when we pass a law in one of our communities and the people pass it, or say the, council passes at the local government, it lets people see what it could be and what it can look like, but it's not going to come easily. And just because this could change at some point down the road too. Who knows, right? There's nothing in legal realm and words is guaranteed forever, as we see. And like I said, in the United States, we've seen this past week, big time. So it's a constant fight. This idea that we win and then we can go home and just say, oh, it's taken care of. That's not how this is going to work either. So.
I think that these are stepping stones, even the ones that you might say fail in the moment when the court overturns the Lake Erie Bill of Rights. Interestingly, a legislator in New York State's legislature was interested in introducing Lake Erie Bill of Rights for the state of New York to adopt. And then when in Ohio, in Toledo, the Lake Erie Bill of Rights was overturned by the challenge of one agribusiness corporation, not even situated in the city, overturning more than 60% of the town's voters that enacted the law. We can see that it's anti-democratic, number one. But the other thing, the optimistic side of it for me is that the idea of rights inherent in nature became better known. It became normalized, more normalized, and each time there is another challenge, another battle over these things, the discussion deepens the level of understanding in the popular mind, so that now this legislator in New York has instead introduced a rights of the Great Lakes, of all of the Great Lake systems, the watershed, not just one lake. I think that there's a consciousness that grows out of it, and we may not be able to see it day to day, week to week. But over the past, since 2006, working in Tamaqua, just, a tiny little town, hardly any possibility of having an effect on anywhere else in the world, is now part of a history of a movement, and it's grown, and it has a life of its own. It doesn't belong to anybody, because, and rightly so, it belongs to creation, to the natural world we're trying to protect. And we're part of it, by the way. If we have any self-interest in it, we might want to take that into consideration.
All right, I see some people, we're trying to keep up, but there's so many questions, and we're getting ready to wrap this up. I can't believe, how quickly the time's gone by. And I want to reinforce to everyone that this is our initial take on this decision after being able to read it finally, because most of us don't speak Spanish. And I, again, want to thank Garn for the assistance we received from them, and Natty Green, who's on the call. But we also want to remember, and I think it's come out, but I want to just reiterate that we can't rely on the courts, that it's up to each of us to push in so many different directions, and so even just by sharing what maybe you learned something tonight, or sharing the decision when you get it with other people, the educating of other people in our community, yeah, possibly it's direct action, and maybe it's even alternative systems to challenge what's unjust, and creating a new cultural awareness, right? And a system that reflects the values and connection of humans and nature. So I think it's all really important, and it isn't going to be one thing. So again, to help us plan for the future conversations we want to have, we know it's beautiful weather out. People don't want to be on Zoom and webinars right now. So we appreciate everybody who's here. But we're planning several more for the fall, and a series on rights of nature and the rights of nature movement. We're going to send you a short Google form that Chad mentioned, and ask you to complete it so you can help shape, give us input, what you think would be the most relevant and important dialogues for us to have. And so then we can then invite people on with us to talk about those things. Also, watch your email for follow-up emails from us that will have the links to the decisions. We also did a short, because in case you aren't aware, the decision is about 120 pages. And we know that not everybody's going to want to read all of that. So we did kind of like a highlights. We pulled some things out, and that's only about 23 pages. So we'll be sending that to you. And also the link to this webinar. I saw someone in chat ask that. There is a video that's being recorded right now. And so we will share that with everyone. So I just want to go around to Terry, Chad, and Ben, and ask if you have anything that you want to say before we say goodnight to everyone.
I just want to suggest if people would like, they can save the chat, which of course already has the URL of the decision, as well as some of the other comments and questions that were being asked. You go down to the bottom right-hand corner where the three little dots are and click on them, and it says save chat. So help yourselves. Thank you. It's quite a pleasure and a privilege and an honor to be talking to people from so diverse a number of countries and about this topic. And the one thing I would say is that thank God you're getting it, because we have a long way to go here, a long way.
Yes, I'd like to thank everyone for being here and sticking with us. And I hope that this has been helpful, at least in starting your thinking about a little more deepening of thinking about rights of nature. And this decision certainly has sparked our thinking on it. We're going to be doing more discussions, more webinars, as Tish said. And I am very optimistic about this, but I also want to that there are, I would say, pseudo rights of nature efforts, or things that look like they're a good idea for protecting nature that really amount to the monetization or the subordination of ecosystems to the economic system. And we'll have an opportunity to talk about those as well. And I'm certainly happy to see that the Los Cedros decision has no part in that, that I can see. So, but thanks everybody for being here. And thanks for Tish for manning the ship there.
Thank you, Terry. I always like it when I get to learn something new about Zoom from you. And so it's quite a privilege. And yeah, Tish, thank you so much for putting this together. You've done the majority of the work on this. And so thank you for leading us through. And yeah, I think from my perspective, there's a ton of stuff within this decision, which we'll be posting soon. It's over 100 pages that has real impacts on how we will go about our work as organizers, as lawyers, as whatever we are. And so I think it's a good moment. And so, yeah, thanks for the opportunity. And yeah, I think the other thing I want to continue to leave people with is, how do we distinguish between human rights to the environment versus the ecosystem's rights to its own existence, independent of us as humans, or as we are a part of it? I think it's a major thing that we haven't spent enough time on. This decision goes into some of that, but it's something that I think needs a lot more thought and more discussion, and we'll be going into in future webinars. So thank you.
Okay, thanks everybody. We're actually going to quit on time so you can go out and enjoy wherever you are. If it's still daylight, nice weather. And it was an honor and privilege to keep the three guys in line. So thanks everybody. And
I want to say thank you to Michelle too. Thank you.
For
very
doing
important.
Yes, and look for your emails from CELDF and check spam, because we're going to be sending several out to you in the next day and week and all that good stuff. So thank you, everyone. Good night.